prepared to speak to this, Mr. Primo.
The council on occasion can close meetings for certain reasons, and we take those. And there's another exception for the open meeting law to allow for attorney-client privilege. We don't do that very often at the city, but on occasion, when absolute confidentiality is necessary, I advise that we close the meeting subject to attorney-client privilege. And in those narrow circumstances in which we do that, then the information contained or discussed in that meeting, the tape or any notes or anything, are not available to the public with a data, open meeting data practices request. There has been a request for that tape from that meeting that was closed pursuant to attorney-client privilege, and I advise Mr. Sarvey to deny the request based upon attorney-client privilege, and that's where we sit today. Certainly the council can waive that if they so choose. I'm certainly not advising that because it's not often used here, but when we use it, it's for a specific reason. And you have your staff report. So, and answer any questions that the council may have on it.
What is the next step that he could take?
They would have to actually file some sort of legal action to have a judge make a determination as to whether or not the information is available to them, and whether or not the council was acting pursuant to the attorney-client privilege, which we were, because there were very specific allegations that were private in nature that had been levied, and certainly that's the reason for the closure.
Well, I guess my question is, do we have to make a motion to deny it, or do we need to just not take action?
Well, you could deny the request based upon the letter that Mr. Sarvey presented to the requester indicating that the data is not available to the public pursuant to attorney-client privilege.
There is a chance that this could go further, so just so the council's aware of that. These things, as we found out recently, that all these, it's not black and white. Someone else could review this tape and determine that portions of the meeting, correct me if I'm wrong, but portions of the meeting may be under that privilege and some portions may not be. It depends on how far afield we went during the discussion.
There would have to be a determination whether or not the meeting was appropriately closed due to attorney-client privilege. And if a judge ruled that we release the information, we release it. But at this point, it's really your attorney indicating that it was closed pursuant to that privilege, and that's where we sit.
That's what we had the closed meeting for.
That's correct.
I mean, it was all cut and dried as I'm concerned. That is not public information.
Well, the information wasn't public anyway that we were discussing at the meeting. That would have been closed and it would have been available by tape later. But there were very specific things that we discussed that were related to a very specific grievance that needed confidentiality, and that's you weigh that, the need for the public to know against the need for confidentiality, and that's what the attorney-client privilege is there to protect.
And again, we closed this to discuss agreements. This had nothing to do with the specific individual's work product or concerns about that.
That's correct. It was related specifically to that grievance, and then we gave a summary at the end of what the result of the meeting was. So
that's pretty clearly laid out in the minutes.
Correct.
So my opinion is that the deliberations that you went through were subject to that privilege and should not be made available.
As I stated in my letter to Kurt, though, I don't take this very lightly, and that's why I wanted to bring it to the council. data practice requests are, you know, these are major concerns and they need to be dealt with, you know, at the highest level.
Well, what is the reason for them coming back and wanting to listen to the tape anyway?
I don't think it even matters.
It's all cut and dried.
I don't think it even matters.
There may be a concern that there was a discussion about his work or something that was more of a personnel nature.
Well, I don't really want, I'm not advising the council to get into the deliberation about the meeting that's confidential.
Exactly.
I would prefer that you just make a decision on whether or not you want to release the tape, and then forego any other discussion about that meeting.
I'll make a motion, we don't release the tape.
I'll second it.
Motion by Mr. Culbertson, second by Mr. Dahl.
I don't see any reason why we would need to either. The summary of the meeting really is in the minutes.
Any more questions? All in favor of the motion, say aye.
Aye.
All opposed? And the motion passes, thank you.